Okay, so page 1 through 30, please. Richt versus Affinity Lifestyles, case 831-880. I would have called you first, but somebody had a plane to catch with family issues, so I appreciate it. Trying to take care of people. Emergencies first. Counsel, would you like to make your appearances, please? There's nobody on behalf of plaintiff, is that correct?
Yes.
Is there somebody on behalf of Richt? No, I'm gonna ask for other plaintiffs in a second. Give me a quick second. Is there anyone here on behalf of Richt? No. Okay. Counsel for other plaintiffs, would you like to make an appearance?
Good morning, Your Honor. This is Brianna Switzler. I'm appearing for plaintiffs Gonzalez, Alexander, and Adesnova.
Thank you. So I need that clarification, please. Okay, counsel for defense, Hannah or Milwaukee, who's going first?
I'll go first. Christian Ogata from Milwaukee Instruments.
Chad Pierce on behalf of Hannah Instruments in the city.
Thank you for your safe comments. Appreciate it. Okay. Well, in that case, let's see. Since you appeared first, you'll go first. Plus you got the pro-bono case. So defendant Milwaukee Instruments motion for summary judgment on plaintiff Jesce Richt's claim only. Document 396. The court did not receive an opposition, not see a reply. Counsel, you know, I'm gonna ask the question, the due process questions on service. So walk through those, please, and then your motion. Go ahead, please.
Yes, Your Honor. So Mr. Richt was served with all three sets of, or with the set of discovery requests, which included the requests for admission. The certificate of service is included. He was served via US mail. As of this morning, neither Milwaukee's former counsel nor us have received any return mail indicating it was returned as undeliverable. Mr. Richt also received or was also mailed a copy of the motion itself. And we sent him a copy of the notice of today's hearing as well.
Okay. And so substantively, go ahead, please.
Your Honor, this court should grant Milwaukee's motion for summary judgment either under Rule 30 or based on the Rule 36 admissions, or even if it didn't look to the Rule 36 admissions, can grant the motion under 56C. Because no opposition was filed, this court can consider the undisputed facts as undisputed and grant them based on that motion. I think two facts or admissions are critical here. The first of which is that Mr. Richt has admitted both in under Rule 36 and 56C that he did not sustain any damages related to any of his claims against Milwaukee. The second admission is that the product that Milwaukee's product was not defective. To state a strict liability claim and or to state a claim for warranty, as Mr. Richt has here, he has to prove damages and he has to prove that the product is defective in some form. Because he's admitted that the product was not defective and did not suffer any damages, this court can grant summary judgment either based on his admissions or based on 56C.
Okay, anybody who's present want to be heard? Do you need to just double check one thing, which I think I already know the answer to, but sometimes I don't get the information just as quickly. There was a statement made, and this may be more for counsel for the other plaintiffs, might be able to answer this one, that this case was going to be consolidated with another case. I have not seen anything come across from this department yet, a notice. I just want to make sure I have jurisdiction to hear this case that hasn't been transferred.
Yes, Your Honor. This is Brianna Switzler on behalf of the other Gonzalez, Alexander, and Adesnova. We have filed a motion to consolidate. That motion just has not been heard yet. If the court grants that motion, as soon as we get an order, you will submit notice.
Sure, no worries. I knew that was somewhere in the works. I wanted to make sure that it hadn't happened because I need to make sure I can hear today's motions, right? Okay, so with counsel for Hannah, before I have you, are you just going to give me the same heads up? Okay, no worries. Thank you so very much. Okay, so for defendant Milwaukee Instruments motion for summary judgment on plaintiff Jesce Richt's claims only, that said motion is granted on the two independent bases stated in the pleadings and here in oral argument. It's both under the admissions being deemed admitted, 34 for 36, and also under 56C and EDCR 2.20 for being unopposed, two independent reasons. I'm adopting the analysis in the case law set forth in the pleadings rather than articulating them here independently. Here in court, unless somebody would like me to set forth the case law that you set forth in the NRCP provisions that you set forth in the pleading. Would you like any more details or adopting it? Would that meet your needs?
That's perfect. Thank you, Your Honor. No need.
Does anybody else wish the court to say? Okay, appreciate it. So being clear on that. So now let's get to, and as soon as you know, under EDCR 7.21, you've got 14 days. Do make sure you circulate it to Mr. Richt right before you send it back to the court with some time, and then we can get that taken care of. Just remember, you all have to coordinate your timing on different things. Because if you're asking this department to sign an order, make sure it's still in this department. Thank you. Counsel for Hannah Instruments, SID USA, Scientific Instruments Development International, your motion for summary judgment on plaintiff Jesce Richt's claims only, document 391. Go ahead, please.
Yes, Your Honor. We had originally had this heard, and the issue was the due process on the hearing. We had already talked about and had argued how we had served the request for emissions at the address with return prepaid postage and envelope for him to bring back. We have not received any responses to that written discovery. On the 7th of March, we resent the motion for summary judgment with the court's minutes dated March 5th, saying that the hearing would be today. We have received, again, no response from him. Going to the merits of the motion, just like Milwaukee, two bases. The one being that he's failed to file an opposition. The second is that it is deemed admitted, certain part, it is deemed admitted, the Rule 36 request for emissions, and the particularly at issue is to jump to the case. He has no proof of any real water products, is not presently experiencing any pain or discomfort, has no evidence that moving parties or the actual constructive notice of the dangerous condition, is not making any claim for future damages, has no proof that defendant SID US Inc. or Scientific Instrument Development International are alter egos, and has no witnesses to the incident he alleges in his complaint. There's other factual, but I think that is enough to satisfy the burden for our motion.
Okay, thank you. So the court's incorporating obviously the pleadings as well as the prior oral argument. The court is satisfied that the due process elements have been met as set forth by counsel in open court. With regards to all notifications to the court grants. Defendant Hannah Instruments, SID USA, Scientific Instruments International. Did I skip one?
Scientific International Development, no, Scientific Instruments Development International Inc. That would probably should have been the one that got abbreviated, but it didn't, so.
Okay, defendant Hannah Instruments Inc., SID USA Inc., and Scientific Instruments Development International Inc.'s motion for summary judgment is granted. It is so ordered on both independent bases, the 3436 and the 56C, adopting the arguments and pleadings, confirming the due process aspects have been met. And so therefore that one is granted as well. Anybody wish me to articulate each and every cases that was set forth in the pleadings, or since I've cited the rules and adopted with regards to the pleadings, anyone else want anything further on that, counsel for Hannah
Thank you.
at all? Counsel for Milwaukee? For the other plaintiffs, not Mr. Richt? Okay, and calling one last time, making sure we don't have Mr. Richt or someone on his behalf. We do not. Okay, it is so ordered that one is granted as well. In addition to 60, I should have also stated EDCR 2.20. Same with you, counsel, please. EDCR 7.21 to the DC 31 inbox in accordance with the administrative order. The quicker you get it circulated to Mr. Richt, please, and then back to the court to review. And same thing on the timing thing that I just mentioned. If you don't have any confusion with who's signing your order, I appreciate it. Thank you so very much. Is there anything else the parties can requesting the court at this juncture on Richt versus Affinity Lifestyles.com Inc. et al. Case 831880. Counsel for other plaintiffs, anything on your end?
Nothing further, Your Honor. Thank you.
Counsel on Milwaukee, anything on your end?
For us.
Counsel for Hannah.
Nothing, Your Honor.
Appreciate it. Hope everyone has a great rest of your day and week. Thank you so
You too.
very much.